Mr. President, in accordance with Standing Order 66-1, I beg to move that the law reform Zones of Special Operations, Special Security and Community Development Measures Bill 2026 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that the law reform Zones of Special Operations, Special Security and Community Development Measures Bill 2026 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Honorable Senators, we have the bill that is before us has 28 clauses, one schedule, and a preamble. Now, we have before us some 7 sets of amendments by 7 senators. So we would like to ensure that the senators in question would be seized of those amendments that are before us, so that everyone would be conscious and aware of those amendments. We have Senator Dr. Desiree Murray. She has some amendments before us. We also have Senator Michael De La Bastide. We also have Senator Marlene Atz. That's 3. We have Senator Anthony Vieira. 4. We have Senator Lolita Etienne, number 5. We have Senator Foster Cummings, number 6. And then we have Senator Faris Alwari, number 7. Just want to make sure all members would have in their possession these 7 sets of amendments. Now, we are going to proceed with these clauses, with the bill, I should say, clause by clause. And when we reach the particular clause where there are amendments from either one or two senators, we shall pause, take the amendments, allow them to articulate those amendments, and we'll put it to the floor thereafter. Yes?
May I, for your guidance, and then perhaps an effort to make this easier, if I may inquire, I heard the Honorable Attorney General in his proceedings, in his wind-up, indicate that we probably are in a position of not taking any amendments. If so, and appreciative of that position, I would propose, for example, in my own amendments, merely to state them for the record, not by way of any debate or other position, but it would help us to understand whether there's room to push or not. So I was just hoping for your guidance through you, Mr. Chairman, so that we can perhaps at least have the record perfected as opposed to any argument on it.
Yeah, well, I'm happy that you raised that point because having regard to what the Attorney General indicated in his closing remarks, I would have liked to get from our senators whether they would like to pursue their amendments or whether they would like to withdraw their amendments in light of the fact that the Attorney General has indicated that the government appears not to be, I wouldn't say interested, but they would not be acceding to any amendments during this period. Am I correct, Attorney General?
Chair, I hate to correct you, but I don't think that I used that language. What I said was that there were a number of factors.
Yes.
I will try to impart this. One, the fact that we are maybe 72 hours away from the end of the state of emergency, and we wish to have something in place by then. Two, the fact that there are a number of what appear to be very substantial and these are not amendments that one can dismiss. They are amendments, substantive amendments, which require some careful thought that the legislation is really what we would describe to be a model law, that even what might appear to be the most straightforward amendments, we wish to have technocrats, and by technocrats, I tell you what I mean. The police who got a raw deal here today, in my view, the Chief of Defense Staff, the intelligence agencies, all of them have helped all of them are stakeholders in this. Of course, the Law Reform Commission. And the 50 amendments the bill has generated a great deal of interest, so that you have a number of senators making a number of suggestions. As I say, some of them seem to be, to me, to be very attractive, but you have an interplay between the amendments which those senators have made and other senators have made. It is difficult for us, and we've taken the policy decision that the bill will, there are a couple of options open to us. And insofar as this piece of legislation is concerned, we would like to pass it as is. We do not go back to the House of Representatives until Friday. we like to pass it as is. Look at perhaps a way to engage with senators. I heard a suggestion from Senator De La Bastide. I'm not sure how, I mean, I've been in the Senate for a while. I'm not sure how that works. I had an excellent working relationship with Dana Sitahal, but that was because we were friends. I'm not sure how it works in terms of liaising with the independent bench, but we would like to develop some sort of mechanism. Yesterday in Joint Select Committee, I had a really good exchange with Senator Vera. Some mechanism in which we could exchange views and decide, well, okay, this is a red line for us. This is not. This is something that we could be flexible on. So we aren't there to, we are nowhere close to that this afternoon. We will not be close to that before the 31st, and something will have to be put in place on the 31st. That is what our intelligence agencies tell us. So the Senator Arawi is correct in that we are not able to take amendments this evening, and I apologize for that, because that is not the way we normally do business. But then this debate has gone on for a considerable period of time. Part of it, I'm not, I don't want to take ownership, but I have not been here for some of that time.
Okay, thank you. Senator Vera.
Thank you. Thank you, AG, for making that clear. Just for the record, two things. I personally am disappointed. When I listened to you and Minister Sturge initially, I was under the impression that government might have been open to taking amendments. And I know all of us worked very hard in trying to put forward the best amendments we could in good faith. Secondly, we do recognize that there's a lot of repetition. So we have tried amongst ourselves to see if we could cull amendments that were overlapping with each other so that things would move along briskly and avoid tedious repetition. And last but not least, I don't think we'll be engaging in much debate. I think, like Senator Alwari, we will simply put our recommended amendment on the record and move on from there.
Okay. All right, well, we have 28, as I said, clauses, one schedule, and a preamble.
One more question for guidance, please,
Yes.
Mr. President. Mr. Chairman,
Yeah.
in drafting my own amendments, I have gone in sequential order, beginning with preamble, which is the last in the normal course of things, and I've suggested insertion of several new clauses. Would you, in tabling these matters, guide me on when it will be appropriate to table what are new versus what is to come at the end? So, for instance, you may begin with clause 1, I may have a new clause 2, but you may take those clauses towards the end. So if I may, for the record, rely on your guidance as to when I can put those submissions on the record. Thank you.
Yeah, I think what you have said is quite correct, and I think we should proceed along those lines. So, as I said earlier, and we can probably commence, we have 28 clauses in the bill, one schedule and a preamble. And we can all agree that the first two clauses before us seem to be a bit harmless. There are no amendments, that is, to those two clauses. Am I right? Clauses 1 and 2. All right, well, let's do just clause 1.
Yeah, just clause 1 and then we do clause 2.
Okay, so Senator Alvarez, you have an amendment to clause 2.
Yeah,
So
I
before
would
we
be
go to
withdrawing
clause
that
2,
one. Yeah.
let's deal with clause 1.
Sure.
All right, so, let's go.
Clause 1.
The question is that clause 1 stand part of the bill. The question is that clause 1 now stands part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that clause 2 stand part of the bill. Senator Alwari.
Mr. President, I withdraw my proposed amendment to clause 2. Thank you.
All right, so Senator Alwari has withdrawn his amendment to clause 2. So the question is that clause 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. Clause 2 now stands part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. I think there is an amendment to clause 3 by Senator Anthony Vieira.
Very briefly, Clause 3 provides a blanket constitutional override of Sections 4 and 5 of the Constitution. While Section 13 permits this, a blanket override raises concerns about proportionality, necessity, and long-term precedents. I felt that derogation should be specific, not general. Parliament should be clear about which rights are limited and why, and limits should be no broader than strictly necessary. The proposed amendment seeks to narrow and articulate the override accordingly. Thank you.
General, would you like to respond to clause 3? The amendment.
We'll note it.
The question is that clause 3 be amended as circulated by Senator Anthony Vieira. Those in favor say aye. Aye. Those against say no. Clause 3. Clause 3 will not be amended as circulated by Senator Anthony Vieira. Is that clause 3 as amended? Now, clause 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Chair,
Clause 3 now stand part of the bill.
Chair, when I said that I would note it, I did mean that I would note it. I meant that I would consider it. So I know that for the purposes of the bill and the exercise that we are engaged in, that we have to do our business. But we have the technocrats have flagged it, and I will consider it going forward. I'm not sure what the mechanism would be. I just want to say that.
Okay. So, AG, when you said you'll take note of it, you'll come back maybe subsequently
Yes, so
with maybe an amended version later on in maybe
we will look at it.
you'll
We'll
look at
consider it.
in the future. Right? Okay. Okay. Thank you. So, yeah, clause 3 now stands part of the bill.
Clause 4.
The question is that clause 4 now stands part of the bill. We have Senator.
Thank you, Mr. President. Mr. President, for Clause 4, I thought it would make neater sense to just simply define minister in the interpretation clause, because it's just repeated throughout as the minister with responsibility for national security. So it's usual to put that definition in the clause. Thank you.
Attorney General, would you like to respond?
That I do not agree with, Chair. We regrettably, we don't think that it is required.
Clause 4 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. The noes have it. I think the noes have it. Close. The question is that clause 4 now stands part of the bill. Those against say no. Clause 4 now stands part of the bill.
Clause 5.
The question is that clause 5 stands part of the bill. Senator Alwari?
Thank you, Mr. Chairman. Mr. Chairman, the rationale behind the amendments that I have proposed for Clause 5 oscillate around the fact that emergency powers of this type are usually in our Constitution solely vested, in our Constitution solely vested in the President. In 2017, when the law reform had drafted the bill taking its first pass at it, we had included that it would be the President who would be the originator of these types of powers. For these reasons, in Clause 5, I propose 4 respective amendments which treat with that principle, where we propose that it is the President on the written request with reasons of the Prime Minister and Council to declare an area zone. The reason why we're requesting the written reasons of the Prime Minister is to shore up the proportionality that can happen with due process, particularly with judicial review, so that reasons can be discoverable. It would give us the manner akin to the emergency powers where a statement of Her Excellency the President is debated. Particularly in the second amendment proposed, we specifically propose that police powers are left to the police. And in Roman 2, in deleting paragraph 2 and proposing a new paragraph C, we're proposing that the objects of the bill are to allow the police to conduct law enforcement and exercises in zones, and that they may do so with the aid and support of members of the Defence Force, who themselves shall not exercise police powers. And that is taken from the root of the Police Service Act, Chapter 1501, Section 43, which allows the police to call in aid assistance, and also under common law in the Comitas principles that exist there. The next amendment, similarly, is to allow police to search a person or vehicle without a warrant, again with the aid of the Defence Force. The further amendment in Roman 4 is to allow the police to arrest or detain without a warrant, again with the aid and support of the Defence Force. The reason that we propose that we cleave the Defence Force out of exercising police powers is because we hold the view that the Defence Force answers to the Minister of National Security and the Defence Council, which is chaired by the Minister. There is therefore, in the sense of the Hines case principle and the principle of Lord Diplock, no service commission of the type to protect against the use of an army for the personal or use of a political purpose. I don't mean that against this government per se. I'm using from the dicta of Lord Diplock. It is for those reasons that we propose, therefore, that it would be by far a more legitimate aim and rational proportionality connected with our constitutional exceptions that we give police powers and move away from the defense. We agree that the defense force may be used in aid of police support, as they have been used for years in joint commands, in joint actions, but in those circumstances, the police alone exercise powers. The last thing that I would say here is that the Constitution is constructed in our respectful submission such as to allow the President and only the President to be the Commander-in-Chief of the armed forces. It is constitutionally, therefore, an aberration to insert the Prime Minister, whether in council or not, as the Commander-in-Chief of the executive forces, therefore raising serious issues with the constitutionality. I've accepted that the Honourable Attorney General has already answered some of my submissions in a very brief form in his winding up. I don't propose to enlarge the debate. I make these comments for the purposes of the record in the event that it needs to be used in aid of other proceedings. Thank you very much, Mr. President. Mr. Chairman.
Chair, I have spoken to this before. The power of the President is largely ceremonial, including her power as Commander-in-Chief. This is not a state of emergency, of course, in respect of which she does not act alone. The need for speed and the need to have an effective law legislation, this is not state of emergency in place, requires, in our view, that the Prime Minister in council, which I'm happy that Senator Arawi was forthright enough to say it may have been in his earlier draft. His later draft has the Prime Minister, not the President, and that we prefer to stick with that. So I've already expanded on it.
Okay. All right, Honourable Senators, the question is that Clause 5 be amended as circulated by Senator Alwari. Those in favour say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 5 now stands part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clause 5 now stands part of the bill.
Clause 6.
The question is that Clause 6 now stand part of the bill. I see we have amendments from Senator Vieira, SC, Senator Michael de la Bastille, SC, and we also have Senator Alwari. In that order, Senator Vieira.
No, I believe Senator Arts too, Chair. I think she goes before us. Yeah.
That is Clause 6.
Yes, Chair.
That's a new clause. That will come later.
Will come later, okay.
Yeah, new clause.
Okay.
Right.
Thank you, Chair.
Yeah.
The terms rampant criminality and threat to the rule of law and public order are undefined. And I accept that flexibility is necessary, but undefined discretion invites allegations of arbitrariness. It can fuel claims of political or racial targeting, and it weakens judicial deference if challenged. My proposed amendment seeks to define these terms by reference to objective indicators such as crime, data, firearm prevalence, organized criminal activity, enforcement, failure. It seeks to preserve executive discretion while structuring it, and it aligns with administrative law principles of reasonableness and relevance. I do believe objective criteria protects the executive as much as they protect citizens. They make decisions defensible, not weaker. Thank you.
Senator Michael de la Bastille.
Thank you, Chair. Thank you, Chair. Chair, I just take this opportunity to say that based on the other proposed amendments, and based on the comments and statements of the Honorable Attorney General with respect to amendments, I'll be withdrawing all of my proposed amendments except for when we come to clause 22. So I'm sure everybody will be happy about that.
Thank you very much, Senator. That was it. Senator Vieira?
Thank you. As we were looking at 6, I had 2 amendments. One was for 6(1)A and then 6(3). So I don't know if anybody else wants to speak to 6(1)A. I can wait, but I just have a 6(3) also to speak to. Thank you.
You can speak.
6(3) goes to clarifying the criteria for zone selection. The bill doesn't currently require decision makers to consider whether less intrusive measures are available, proportionality to the threat, or the impact on law-abiding residents. So the rationale for the amendment is by requiring the Prime Minister and Council to have regard to necessity, proportionality, alternatives, and community impact, the amendment would embed constitutional culture into decision-making and counter claims of arbitrariness, and hopefully strengthen the bill against judicial review.
Senator Alwari, you have some...
Yes,
you have an
thank you,
amendment?
Mr. Chairman. Mr. Chairman, I have proposed 6 amendments to clause 6 as originally numbered, and if I could go through them in series and succinctly. The first thing is that in agreement with submissions for other reasons, but other senators have raised the issue of the vague aspects of interpreting rampant criminality and threat to rule of law. So I've sought to join them to say in 6(1), where there are reasonable grounds to believe that there's rampant criminality, gang warfare, escalating violence and murder, so as to be a threat to the rule of law and public order. I've taken that approach, borrowing the language of the emergency powers run up to the wicket in the Constitution, which sets out, we consider that the simple split of the threat to rule of law and public order is by itself simply too vague and can lead to potential abuse. Again, speaking in the abstract and not pointing a finger to anyone. The second thing is that borrowing from the 2017 draft of the law and borrowing from the Jamaican Act, we have proposed that we insert that there is the written agreement and advice of the Commissioner of Police and Chief of Defence Staff. This would be so that you would insulate a Prime Minister from an allegation of political activity as opposed to law enforcement activity. Again, because in our humble submission, it is not the role and function of a Prime Minister to be a person who triggers powers such as this. It's not found in our law, is our submission. The Constitution provides that the President is much more than ceremonial in our respective view, that the President, when acting in the Constitution, whether under Section 80 of the Constitution or otherwise, may do so in his own discretion. And again, we say that the President may, after due consideration on the written advice and reasons of the Prime Minister and Council, declare any geographically designed area. Borrowing from our 2017 draft and from the Jamaican law, we consider 180 days to be too long a period, and we have proposed 60 days because this is an entire period during which there are emergency-type powers and privilege given to the defence force to act where they don't have powers and privileges of the police in law. In the third amendment that we propose that one ought not to be in the position of declaring the whole of the island of Tobago or the whole of the island of Trinidad as zones by themselves, but that one may have parts of both islands declared. This is to give rationality to the precedent that we have in the disaster measures legislation, and therefore to make sure that we weren't really using a backdoor substitute for constitutional states of emergency. One ought not to have the whole of the island of Trinidad or the whole of the island of Tobago. We have also proposed, in keeping with our submission, that the President is the one who makes the order, that within 3 days of making the order, the President shall deliver to the Speaker for presentation to the House a statement setting out the specific grounds on which the decision to declare a zone was based, and shall fix a debate for that statement and for the affirmative resolution of the House. We do that, Mr. President, borrowing from the precedent that we have in sections of emergency power in the Constitution, and again, keeping the exercise of executive power, in our view, pursuant to Section 74 of the Constitution, in the hands of the President of the Republic. The last thing that we do is, second to last thing that we do is to say that unless the order is previously revoked, it shall last for 15 days, so it gives regularity. In proposing this course, and in having the statement of reasons and the affirmative resolution, it would remove, in our view, all doubt of constitutionality, and it would ensure against judicial review going in the wrong direction for a government that wanted to uphold a special zone of operation. The last position was a backup plan for discussion, that if one wanted to avoid an affirmative resolution route, as proposed in Roman 4 of these amendments, that the Attorney General could have considered instead a negative resolution by the Parliament, which is in keeping with another aspect of the bill. These are my submissions as to the amendment to Section 6, again driven to shore up the constitutionality, allow police to exercise police powers, allow the President to insulate the government from any allegation of political potential abuse, and to shorten the timeframes and regularities of the period. Thank you, Mr. Chairman.
Very much. Attorney General.
Chair, I would like to consider again Senator Vera's points. I disagree that and I'm repeating myself, that the President is anything but ceremonial insofar as her powers as Commander-in-Chief of the Defense Forces are concerned. If one draws a reference to the United Kingdom, it would be a constitutional heresy for there to be an issue of any type, national security issue, in which the King or the Queen, as the case may be, decides that she's sending the SSE or whatever you call it, the SAS, to go raid somewhere. It's just not done. So I don't want to use, stronger language than to make the point that even in respect of a state of emergency, I know it because I have done it before. The Senator knows it. The President acts on the advice of the Cabinet and is very careful to ensure that her actions align with the reasons given by the Cabinet for the declaration of the state of emergency. So I disagree with that. So that's it.
Mr. Chair, is there a possibility that you would allow me to ask a question? And it's directed to the Honorable Attorney General. In the light of Senator Vera's proposed, what would have been his proposed amendments, my question is, how is it in the drafting of this Section 6, where the power is specifically being given to the Prime Minister in Council, how come in this section there is no protection, as it were, for the Prime Minister, or insulation for the Prime Minister, or the person making that kind of order, by building in these conditions or conditions similar to these? How come that's not here?
In these conditions, what?
So essentially, when you want to show that you're acting proportionally or you're acting reasonably in all of these circumstances, you show that you are ticking the right boxes.
Correct.
But there is a sort of very broad, the language of this section is very, very broad and makes it easily challengeable for that very reason.
I disagree with, not I disagree. Senator Arawi is wrong when he says that there are written reasons in Jamaica. The act in this respect is a mirror of the Jamaican statute. Now, one can say that there ought to be criteria, but those criteria are not set out in the Jamaican statute. The Jamaican statute is what is repeated here and what Senator Arawi had produced.
Well, sorry to interrupt, AG, through you, Chair. I wasn't concerned with what Senator Al-Rawi had said at all. And I know that you're saying that this is a case in Jamaica, but I was thinking, well, if we are legislating, shouldn't we be producing the best legislation then? And certainly I found myself having a lot of sympathy with what Senator Vera had proposed.
So,
It seemed to be a rational approach to it.
right. So did I, and that's why I made the point that that is something that I would consider. So I would have to circle through my stakeholders, but my point was with respect to...
Mr. Chairman, in a very succinct position, as the proposal is my proposal that we're considering, and it would be usual for me to make the statement at this point. Just for the record, Section 4, subsection 6 of the Jamaican legislation specifically says, have agreed in writing that the area should be so declared on the part of the Commissioner of Police and the Chief of Defence Staff. It does not provide for reasons, which I have included in this draft, but for the record, I've suggested reasons for the insulation of the Prime Minister against judicial review. I just want to make it clear that I'm deliberately attempting not to use any caustic language so that I can keep the points as succinctly as I can for the benefit of the record. But for the record, I would like you to note the constraint that I'm putting here. So I have been faithful to what I said the Jamaican law has. I can produce it for you. It's in writing. So just to put it on that point by way of the final submission.
The question is that Clause 6 be amended as circulated by Senator Anthony Vieira, SC. Those in favor say aye. Aye. Those against say no. No. The noes have it. The question is that Clause 6 be amended as circulated by Senator Al-Wari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 6 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 6 now stands part of the bill. Right.
Clause 7.
The question is that Clause 7 stand part of the bill. We have two amendments according to what we have before me. Senator Dr. Atz and then Senator Al-Wari. In that order, Senator Atz.
Thank you, Chair. At this time, I wish to withdraw my proposed amendment under Clause 7.
Okay, thank you very much, Senator Atz, Dr. Atz. Senator Al-Wari, please.
Thank you, Mr. Chairman. Mr. Chairman, in Clause 7, I propose 4 amendments as set out. The first amendment is to seat the Prime Minister in Council making a declaration for a variation of a zone, whether in time, geography, or extent, or otherwise, after consultation with Joint Command and where the Commissioner of Police and Chief of Defence Staff agree in writing with reasons. The in writing is borrowed from the 2017 draft and the Jamaican legislation. The reasons is new. That is intended to provide a shore-up of protection for the Prime Minister to protect us in judicial review proceedings and otherwise. It again locates the authority to the President, who may after due consideration, subject to the law, extend as has been suggested. We propose in the second amendment to Clause 7 that within 3 days a statement is made, that statement gives the reasons and is presented to the House for debate for affirmative resolution. It's in keeping with the bill as it's tabled in Clause 7, where an extension is done by affirmative resolution. In the circumstances, we've sought to marry the provisions, borrowing from the approach that is used in the Constitution. We propose, in keeping with our 2017 draft, as well as the Jamaican law, that the time frame be reduced from 180 days and kept at 60 days and no longer. And then we propose that we delete Clause 7.3 as originally numbered, and that is specifically, Mr. President, so that we could marry the amendment taken care of in the first position. We've done that in keeping for the submissions that we've offered in relation to Clause 6, which I won't, in the interest of time, repeat, but which I rely upon. Thank you.
Okay, the question is that Clause 7 be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 7 now stands part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 7 now stands part of the bill.
Clause 8.
The question is that Clause 8 stand part of the bill. Senator Dr. Ertz, you have an amendment here.
Thank you, Chair. I wish to withdraw my proposed amendment to Clause 8.
Okay. The question is that Clause 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. Oh, you want to say something? Yes, sir. Okay. Yeah.
Yeah. Thank you, Mr. President. For the record, I had proposed, in keeping with my amendments above, that Clause 8 be deleted because we had proposed that the affirmative resolution be part of Clause 7 as amended. Thank you, Mr. President. Thank you, Mr. Chairman.
Be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 8 now stands part of the bill.
Clause 9.
The question is that Clause 9 stand part of the bill. Senator Alwari.
Thank you, Mr. President. Mr. President, Clause 9 of the bill we propose be amended as circulated. In Clause 9, as it's originally put, it's that the Prime Minister in Council may, on his own motion or on the recommendation of Commissioner of Police and Chief of Defence Staff, revoke an order with the declaration of a zone. We propose instead that the order declaring a zone may be revoked by the President, again in keeping with the centrality of command and the Constitution with respect to the Defence Force, after due consideration, acting on the written advice of the Prime Minister, who in turn must receive the written recommendation of the Commissioner of Police and the Chief of Defence Staff. To put the Prime Minister on his own motion is to suggest that the Prime Minister has the authority to deal with criminality which our Constitution does not permit. The police can deal with criminality. The President may declare a state of emergency, but in no circumstances can a Prime Minister invoke those powers in our respectful submissions. For those purposes, we've sought to bring it back to the President, and borrowing from the Jamaican precedent, we've directed ourselves to the written recommendations of the Commissioner of Police and Chief of Defence Staff, protecting the Prime Minister from any claim of improper conduct, particularly on judicial review, because a Prime Minister would be able to rely on those reasons. Thank you, Mr. Chairman.
I don't want this to be a back and forth between Senator Rawi and I, but and I don't wish to read the Jamaican section. Suffice it to say that it does say the order declaring a zone may be revoked at any time by the Prime Minister in Council. We prefer to keep it as it is for the time being.
Let me put a question. The question is that clause 9 be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 9 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 9 now stands part of the bill.
Clause 10.
The question is that clause 10 stand part of the bill. Senator Dr. Arts and Senator Alwari in that order.
Thank you, Chair. I wish to withdraw my proposed amendment to clause 10.
Senator Alwari, the floor is yours.
Thank you so much, Mr. Chairman. Mr. Chairman, clause 10 of the bill we propose be amended in three respects. Clause 10 of the bill, in our respectful submission, is a critical point that deals with the discipline of the rank and file of the joint force. We propose, firstly, that clause 10.3, which says that every zone shall have a written accountability and reporting system as specified by the National Security Council, we go to particulars there, borrowing upon the jurisprudence coming out of the COVID and the Ministry of Health challenges, where our courts held that there must be publication of rules, regulations, and directions and standing orders in the COVID manner. This is the funeral pyre cases, just to remind you, Mr. Chairman. We've borrowed from that learning where the court says that there ought to be publication of these to say that every zone shall have standing orders to establish a written code of conduct to govern any member of the Joint Command and Joint Force, which includes an accountability and reporting system as shall be made by the Minister, meaning the Minister with responsibility for national security, upon the advice of the NSC, after consultation with the Commissioner of Police and Chief of Defence Staff. We do that because we're dealing with two separate pots of authority, the Trinidad and Tobago Police Service and the Trinidad and Tobago Defence Force. And then we say, critically, that it must be published in the Gazette and twice in 2 daily newspapers in wide circulation. And also, we've added the web pages of Trinidad and Tobago Police Service. This is to give notice to the world, apart from legal notice in the Gazette, and therefore it would allow for accountability of persons who go afoul of the law. Because it is later in this clause, so it's later in the Act that you see, sorry, it's here at subclause 5 in clause 10, you see a person who fails to comply with subsection 4 is liable to disciplinary action. In our view, you can't be liable to something that you don't have notice for and that the world doesn't know it ought to bring you up on disciplinary charges because they've never seen it gazetted, it can be changed, there's debate. So we think that the absolute axiom of publication and gazetting is required. We then propose that, in addition, we propose, following upon that, in clause 10.4, that it be substituted by, in addition to such other compliance required of police members and the Defence Force under any other written law. In preparing this, I went to the Police Service Act and the Police Service Regulations and their standing orders, and I also went to the Defence Act and to the Defence Force Regulations. And I can say that in my experience and sitting on the Defence Council for 10 years, I felt that it was important to include that you could be subject to breaches of the law apart from disciplinary action alone. So we have preserved the fact that it may be that you are required to be in compliance with other laws. If you look to the last amendment, it follows from what I've just said, notwithstanding that he may be charged with an offence under any other written law, any person who contravenes subsection 4 commits a disciplinary offence. It therefore avoids any risk of implied repeal or of immunity being offered and reduction of offences being there. It is to avoid the argument. I've borrowed specifically from the Defence and Police Complaints Authority Bill of 2013, which the UNC brought to Parliament many years ago, which did not pass, but which had similar wording to this. So in summary, Mr. Chairman, this is intended to have the publication of regulations, standing orders, guiding principles. It is to allow the population to have notice of it, both legal and actual. It is to allow for the bifurcation and maintenance of both disciplinary and criminal charges, and it is to be cleaved between the TTPS and the Trinidad and Tobago Defence Force. Thank you, Mr. Chairman.
Yes, Senator Vieira.
While we're still on clause 10, just wanted to flag what I see as a constitutional weak point. The National Security Council is not a creature of statute. It is an executive committee of the cabinet. Unlike the Defense Council, it has no legislative framework, no defined powers, no statutory limits. And now this matters because the bill repeatedly vests authority in the Prime Minister in Council and the National Security Council, including declaring zones, designating joint command, suspending operations, receiving operational reports. And this creates, in effect, a parallel command and control structure not expressly contemplated under either the Constitution or the Defense Act. Now, so I see this as a structural constitutional problem. Reporting under the bill is to an executive body chaired by the Prime Minister, the same body that declares the special zones is going to receive the operational reports, and you're creating a closed executive loop. Unlike Jamaica, we don't have a national security advisor. We don't have a robust independent National Security Council Secretariat, and this weakens external security. Thank you.
I do think that we have a robust National Security Council. I take the point that it does not have a personality per se, but it is a subcommittee of the cabinet. And the cabinet has obviously oversight for decisions of the NSC. It has spending autonomy, vast spending autonomy on its own without reference to the cabinet. Now there's a case, the GCHQ case, which says that generally speaking, decisions of the national security are not reviewable or reviewable. The courts give a large margin of appreciation with respect to matters of national security. But I take the point. It's an interesting point. I'll pay attention to it.
Mr. Chairman, just to wrap up now, in the closing of the submission, if there are no others, as it's my amendment, I'm not sure if anybody else wishes to contribute. Thank you, Mr. Chairman. Mr. Chairman, I was saving it for reply, but it's the reason why I had inserted the word minister, because I accept what the Attorney General is saying as the Cabinet's general authority, but I remind that it is usual to have a minister make certain rules and regulations, etc., hence the Minister of National Security. I'm cautious as well that the Freedom of Information Act can be applied such that you can disallow disclosures of the National Security Council. If it comes from the TTDF, you can seal reports and they would be rendered without discovery. It's for those reasons, again, that in the closed loop, if I borrow Senator Vieira's submission of executive authority, that we didn't believe that it is in the best interest of the constitutionality of the law to have the control of police powers vested in a cabinet, particularly in a subcommittee. I've heard the Honourable Attorney General, and I don't propose to be in a debate, but those are the submissions.
I'm sorry, Mr. Chair.
Yes,
One, if you would permit me, one small question to the Honourable Attorney General. The GCHQ case to which you refer, is that not the case that has to do with deal with the interpretation of the English Official Secrets Act? Is it the same GCHQ case we are talking about? And that legislation said that it wasn't reviewable, and in any event, that was in the 1980s.
Security, and it says that in respect of national security, the executive ought to take a hands-off approach. But it is the case.
Yes, agreed. Thank you.
Clause 10. The question is that clause 10 be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. I think the noes have it. The question is that clause 10 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 10 now stands part of the bill.
Clause 11.
The question is that clause 11 stand part of the bill. Senator Alwari.
Thank you, Mr. Chairman. Mr. Chairman, we propose that clause 11 be amended in two aspects of the law. First of all, we propose that whereas clause 11 proposes that the Joint Command should submit a written report to the National Security Council only, I'll add that, every 30 days, we propose that the report be submitted to the Council, the Commissioner of Police, and the Chief of Defence Staff. This is specifically intended to shore up the constitutionality. Why? Under sections 122, 123, 123A of the Constitution, the Commissioner of Police is bound to report to the Police Service Commission every 6 months and otherwise, or on matters that they may seek to discipline a Commissioner of Police or a Deputy Commissioner of Police in respect of First Division matters. Secondly, the Commissioner of Police would have the ability to discipline pursuant to section 123 of the Constitution orders and officers in rank below him having management and discipline that way. This would conform with the regulations. If these reports, for instance, from the Defence Force went only to the National Security Council, or the Commissioner of Police went only to the National Security Council, and there wasn't reciprocity, particularly where the bill proposes that the Defence Force exercise police powers, then the left hand may very well know what the right hand, may not know what the right hand is doing. And more than that, because the National Security Council has no legal status, I should say statutory status or constitutional status, other than by way of being a subcommittee of the Cabinet, and not all national security notes, council notes, go to the Cabinet, we are going to possibly have a vacuum of information and therefore a vacuum of discipline, responsibility, or otherwise. We also propose, insofar as we had made the amendment that we moved down from 180 days, we'd made a concomitant position of a review and submission of reports every 10 days, keeping with other legislation that we have borrowed that expression from. So this was intended to shore up the constitutionality. Particularly, later on you'll see, Mr. President, we have suggested that the Trinidad and Tobago Defence Force, where it is engaged in a joint command, that it is not subject to the Defence Council or the Minister's supervision, because the Defence Act allows, well, says in Section 5 of the Defence Act that the Defence Force is subject to the specific or other or general directions of the Minister. So we had delinked that to say that the TTDF would be insulated and stand apart from the Minister's general or specific control. So all of this is done with a view to ensuring accountability and constitutionality. The second amendment is again to take into account the fact that it ought not to be that if you breach these positions, you are just liable to disciplinary action. We've sought to include the language which says, notwithstanding that he may be charged with an offence under any other written law. And by that, of course, I'm referring to the suite of laws that govern police, because I would remind that police include TTPS, supplemental police, supplemental reserve police, special reserve police, and municipal police. So in those circumstances, we wanted to make sure that all the regulatory laws and offences applied, as well as those that prevail in relation to the Defence Council and the common law. Thank you, Mr. Chairman.
Okay. All right. let me put a question. The question is that clause 11 be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 11 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 11 now stands part of the bill.
Clause 12.
The question is that clause 12 stand part of the bill. Senator Alwari.
Thank you, Mr. Chairman. Mr. Chairman, we propose that Clause 12 be amended such that the Prime Minister and Council shall, on the written recommendation of the Commissioner of Police and Chief of Defence Staff, have the power to suspend operations of the Joint Command. This is specifically to insulate the Prime Minister from any allegations of improper conduct, to be acting upon the advice and authority which would allow for judicial review or other circumstances, so that we could defend against any activity that could be deemed to be other than democratic or otherwise. And I rely upon the reasons given earlier in respect of a similar amendment.
Attorney General, any comments?
I know it's late in the day, but isn't that what the section says already? The Prime Minister may suspend on the written recommendation of the COP and the CDS?
AG, you're correct, but it removes the sole discretion where the Prime Minister and Council, or where the Prime Minister and Council considers it necessary to do so. So we kept with Part A, we deleted Part B, because Part B would leave the Prime Minister and Council on his own, and therefore, without the benefit, it would lead one into the allegation, which could be fed, that a Prime Minister was somehow managing law and law enforcement.
But this is not, this is the opposite of imposing a zone. This is lifting the zone. So, I mean, I don't see how...
I have an answer, but won't give it so that we stay to the brevity of the engagement.
It's the opposite of a right.
Yeah. I could have said the same thing in respect of other things, but I've kept quiet on the undertaking that we keep it brief.
Clause 12 be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 12 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 12 now stands part of the bill.
Clause 13.
The question is that clause 13 now stand part of the bill. Senator Alwari SC.
Thank you, Mr. Chairman. Mr. Chairman, we propose that the Minister and not the National Security Council, why the Minister is given responsibility pursuant to Section 79 of the Constitution, and therefore we've gone to fix the entity that is known in law. We've not taken the proposal of the National Security Council for the same reasons offered earlier about it being a subcommittee of cabinet and without constitutional or statutory provision, accepting what the Attorney General has said as to general cabinet, well-known authority and responsibility. We've said that the Minister shall, on the written advice of Commissioner of Police and Chief of Defence Staff, make a written code, and as opposed to just saying that the code must be in existence, which is what the bill says, we've demanded that the code be published and gazetted, specifically so that A, it has legal authority by way of notice, B, that it is brought to the attention of persons who may wish to activate their rights, and C, so that there is some regularity in the purpose, particularly when it comes to judicial interpretation, and one is asking the question, well, which is the right thing? Version 1, 2, 3, or the one that can't be found? So for those reasons, Mr. Chairman, we propose that Clause 13 be amended as circulated.
I think this is the clause that I would have a serious problem with. You're asking us to publish the names of the officers involved in gang interdiction, gang activity, and to put them in a gazette. I don't see the sense in it. And I mean, I'm sorry if I used intemperate words there, but that is something that I would have a great difficulty supporting.
Thank you, Mr. Chairman. Just in closing, Mr. Chairman, that is not what I have suggested at all. The Minister shall, upon the written advice of the Commissioner of Police and Defence Staff, establish and make written code to determine the method by which the identity. A method may have an anonymous approach. A method may have badge numbers as opposed to other positions. But to hear that the risk of the personalities is in the equation is to raise the severity of our concern, because the Trinidad and Tobago police standing orders and the law allow persons to be with the benefit of the identity of the persons carrying out law enforcement. Badge number, name, usually where warrants are done, the warrant is shown. In fact, you can pull out your phone and record the entire incident. Now I have the apparition of masks and doors being broken down, which cause me great concern, but that is not what I am suggesting at all. This is the method by which, and so that there is transparency in law enforcement, Mr. Chairman. So just to draw the distinction between what the Honourable Attorney General perhaps understood a version of what I said to be, I'm clarifying that that is not it, but his input has caused me even greater concern as to the identity being capable of being found. The last thing that we would want is hooded people exercising the powers of the police where they don't even have it.
Yeah, the question is that clause 13 as amended, be amended rather, as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 13 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 13 now stands part of the bill.
Clause 14.
The question is that clause 14 stand part of the bill. Senator Vieira, SC.
Chair, before I go to my proposed amendment, with your leave, may I share some good news to lighten the moment? I've been informed that Trinidad and Tobago just became the 19th state party to the Escazú Agreement. We have just deposited our instrument of accession at the United Nations. So, heartiest congratulations. Well done, government. Now, my amendment seeks to clarify the supporting role of the Defense Force. The bill permits Defense Force personnel to exercise the powers of a constable in zones, but it does not require police equivalent training, does not require certification, does not expressly preserve the supporting role of the military. And I believe this creates serious risks. Abuse of powers through unfamiliarity with policing standards, evidential failures in court, civil liability, and unhealthy long-term militarization of public order, which I spoke about in the debate. My amendment seeks to require the Defense Force personnel to receive approved law enforcement training, require written certification by the Commissioner of Police, limits certification to the duration of zone operations, and clarifies that military involvement is supportive, not substitutive. If we give soldiers police powers, we must also give them police training. Anything less is unfair to them and is dangerous to the public. Thank you.
Can I ask Senator Alwari if he has any comments on to make on?
Yes, Mr. President. I have a number of amendments I've proposed. So, Mr. President, we propose 5 amendments to Clause 14. Clause 14 is, for me, the nuts and bolts of where the mischief in this law lies in its most apparent way. It, of course, exists in other places. Clause 14, as it's currently set out, is that the Joint Command may establish a cordon. And in the second aspect of that, the Commissioner of Police and Chief of Defence may impose a curfew. It then goes in to say that notices shall be produced in certain aspects. The second aspect of Clause 14 is that it says, for the avoidance of doubt, where a cordon is established or a curfew is imposed, any member of the joint force may, for purposes of enforcing such cordon or curfew, exercise such powers as are vested in a constable. With respect to the amendments circulated, we propose, A, with respect to the cordon, that a cordon may in fact be established by the permission of the Commissioner of Police. So we suggest that the Joint Command may in writing request the permission of the Commissioner of Police to establish a cordon, and that as soon as practicable after the commission may be granted, that a notice is set out. It must be published in the Gazette. It must be published in 2 daily newspapers in wide circulation, and it must be on the web pages of the TTPS and the Ministry of National Security. We also say that you may publish in any means possible. We've borrowed this language from the manner in which SOEs and curfews are done under state of emergency regulations, which can be done under the Commissioner of Police's hand. Under a state of emergency, the normal state of emergency curfew aspects, even though I'm speaking about cordon, are delegated to the Commissioner of Police in states of emergency. We think that publication is critical, again, to have certainty for the enforcement of law in the reciprocal arrangements of rights, those who are enforcing the law and those who may complain about the enforcement of the law. Similarly, in respect of a curfew, we say that the Joint Command may, in writing, again request the Commissioner of Police to impose a curfew, and that the Commissioner of Police may agree to that, again with publication for legal certainty for the reciprocal enforcement of rights. Critically important, our Second Amendment says, for the avoidance of doubt, whenever a cordon is established or a curfew is imposed, members of the defense force who are members of the joint force, that is so you have certainty of characteristic, may, if called upon to assist any member of the police service in maintenance of law and order, and while such member of the defense force is engaged in so doing, shall be under the command and control of the Chief of Defense Staff. And in these circumstances, the Chief of Defense Staff shall not be subject to the general or special directions of the Minister, notwithstanding any written law to the contrary. This is a constitutional safeguard which we have developed to insulate the Minister of National Security away from what the Defence Act has placed him in. The Defence Act in sections 5, 6, and 7 say that the Defence Force is subject to the specific and general control of the Minister, and of course treats with how the Defence Council operates. This gives the political insulation away from the odium expressed by Lord Diplock in the Hines case. This is to preserve also the existing law. Section 43 of the Police Service Act allows for the aid to enforcement by any person for an officer who calls for his assistance, and therefore we were keeping this within Chapter 1501 of the laws of Trinidad and Tobago. We similarly, in our Third Amendment, instead of using in Clause 14.3c, the 14.3c, where it is an officer, we're making sure that it is a police officer who exercises police powers. We've accepted that there may be a need for the Commissioner of Police to have delegated responsibility, but we have felt that an Assistant Commissioner of Police ought to be replaced with a Deputy Commissioner of Police. Why? Because the Deputy Commissioner of Police is subject to the jurisdiction of the Police Service Commission under the Constitution. We propose that 14.5b be amended, and that says that the Chief of Defence Staff may be taken, action may be taken by any member of the Trinidad and Tobago Defence Force. Because of the constitutional risk within the law's caution as the same, we believe that the Defence Force ought to be taken out of that entirely. Those are our submissions on Clause 14, Mr. Chairman.
Chair, on this, I agree to consider the comments made by Senator Rawi and definitely the training comments made by Senator Vera. I think that they have serious merit.
All right. The question is that clause 40 be amended as circulated by Senator Vieira SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it.
Question number 40 will be amended as circulated.
The question is that clause 14 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 14 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 14 now stands part of the bill.
Clause 15.
The question is that clause 15 now stand part of the bill. The question is that clause 15 now stands part of the bill. Those in favor say aye. Aye. Those.
He doesn't have any amendments. He's on 16.
All right. So the question is that clause 15 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 15 now stands part of the bill.
Clause 16.
The question is that clause 16 stand part of the bill. Senator Alwari, SC.
Thank you, Mr. Chairman. Mr. Chairman, clause 16 commendably ensures that seizure, i.e. police power, is done only by police officers. So I was appreciative of that fact. The amendments that we propose, which are 6 in number, are to make sure that the powers are specified. Any police powers are in fact carried out only by the police. So for instance, where you see the word joint force, we make sure that it is a member of the joint force who is a police officer that may take police power action, having preserved already the right to call for assistance from the TTDF. Similarly, if we look at 16.5, and this is by way of narrowing down the risk for any mischief, if we look at 16.5, forgive me, just let me get to the page. Yep. 16.5, the police officer shall take steps as are necessary to ensure. We have asked that it be tightened up. We take away the words, take all steps as are necessary to ensure. Simply put the square obligation to make a list and ensure a receipt is done. To do that, Mr. President, Mr. Chairman, I've reflected upon the Administration of Justice Preliminary Inquiries Act, where search and seizure provisions are put into effect into law, and in those circumstances they simply provide for list and for receipt. But very importantly, instead of confining it only to vehicles, articles, or documents, we've said items, because it may be something more than those specific categories of things. If we went to a JIPA, you see the word items is used to capture the class of things which may be seized. So those are the positions for removing those 3 words, vehicles, articles, or documents, instead items. We have asked for the inclusion of safeguards which exist in a JIPA as well. So where you have seized something, lodge a copy of the list and receipt prepared with the Joint Command and with the nearest police station, or to or in the zone, and make an entry in the station diary. In a JIPA, when you have a seizure under a warrant, it's lodged with the Registrar of the Supreme Court. So here at least we'll have the certainty of knowing what was taken within a structure that is supervised and insulated in the TTPS. We have also suggested that we need to be clear on the powers here of the aid to enforcement. And therefore, we repeat that police powers essentially in a new 16.2 are to be exercised by the police, but that the defense force may be called upon to assist the members in the manner that we set out there, under the command of the Chief of Defense Staff, who shall not be subject to the general or specific directions of the Minister of National Security in the Defense Act. Those are our submissions. They're intended to improve the constitutionality and to take away the risk of Defense Force exercise of police powers without the privileges and immunities in the Police Service Act. Thank you, Mr. President. Mr. Chairman.
AG, the question is that, let me put a question. The question is that clause 16 be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 16 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 16 now stands part of the bill.
Clause 17.
The question is that clause 17 now stand part of the bill. Senator Alwari.
Thank you, Mr. Chairman. Mr. Chairman, we propose that clause 17 be tightened up. This is meant to be a law which would allow for law enforcement, and therefore we believe that anything seized should be for the purposes of evidence in criminal proceedings, and simply that, because after all, we're exercising police powers in seizure of matters, and therefore it should be in keeping with evidence. Specifically, in drafting this amendment, I went to AJIPA, Administration of Justice Preliminary Inquiries Act. I looked at the safeguards set out in AJIPA with respect to how things seized are managed, albeit in those circumstances under warrant. Mr. Chairman, in looking at that, we've said that, again, in clause 17.2, as we propose it is now set out, that the responsibility, in 17.1, we've taken into account of the fact that there may be some items that can't be in the custody of the police alone, so we've included a person authorized by him to receive it. That's an amendment we made in AJIPA, where things just, for instance, in IT technology, you can seize it where it is and have it kept in the custody of IT personnel, for instance, at a telecommunications authority or other method. In the new 17.2 that we put out, again, we've sought to limit it for the purposes of evidence in criminal proceedings, and that is to keep the things in safe custody. In 17.3, we've taken into account the nearly 7 years of amendments that we've had on our books, and that is where in AJIPA we've specifically provided for the use of photographs to secure evidence, as opposed to holding on to the thing, it becoming a wasting asset, and therefore having liability for compensation and return. So 17.3 is taken from the Administration of Justice Preliminary Inquiries Act. 17.4 sets out where photographs or digital recordings or other images are taken, how the returns would be done. I didn't annex to my amendments proposals for the Form 2 and Form 3 in what should be a Schedule 2, not Schedule 1, but I'm suggesting to the drafters that that can be taken from the Administration of Justice Preliminary Inquiries Act. In 17.3, we're seeking again to clarify that it must be a police officer, and again removing the limitation of vehicle, articles, or documents, and instead using things seized. We also propose similar tidying up in 17.4 and 17.5, and we are in the provisions of the last one, we're proposing that you delete no reasonable grounds referred to in subsection 3 and insert reasonable grounds to do so. So let's look at that subsection 3 for a moment. In 17 subsection 3, sorry, 6, because it's renumbered. Sorry, I'm looking at 18, 17. Right, if you look at 17.5 in the bill, a magistrate to whom an application is made under subsection 4 shall order the return of the vehicle, article, or document, as the case may be, to the applicant or to such other person whom the magistrate is satisfied is entitled to its return. if the magistrate is satisfied that there are no reasonable grounds as referred to in subsection 3. Subsection 3 is where you have reasonable grounds, you may do certain things. This just didn't read right. So I think that there's a language inaccuracy here. It didn't. I read it 2 to 3 times to try and make sense of the end of the sentence. Provided that the magistrate is satisfied that there are no reasonable grounds referred to in subsection 3. It would be much simpler if the magistrate said, I'm giving it back to you because I believe I have reasonable grounds to do so, simply. So I couldn't follow the clawback to subsection 3. Those are our submissions, Mr. Chairman.
Okay. Let's close out. The question is that Clause 17 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 17 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 17 now stands part of the bill.
Clause 18.
The question is that Clause 18 stand part of the bill. Senator Dr. Murray and also Senator Alwari, SC. Dr. Murray.
Thank you, Mr. Chairman. My amendment is quite simple. The clause says that at the time of his arrest, the person should be, as soon as reasonably practicable, be told the reason for his arrest or detention. I would like to delete unless the circumstances are such that the person should know. It's my view that everyone should be informed of the reasons for their arrest or detention, whether or not they know the reason. It's quite simple. Thank you.
Thank you, Mr. Chairman. Mr. Chairman, we propose 2 amendments to Clause 18. The first one, in keeping with the philosophy of our amendments, is that where we're dealing with a joint force carrying out an operation in a zone, the arrest should only be by a police officer. It should not be left to the question mark as to whom the officer is, because this doesn't say whether the officer is a police officer or a member of the defense force. That is to take care of the concerns in 18.1. In 18.2, we have proposed that instead of simply saying prison or police station, that we insert the words, effectively, we're keeping with prison, but a child rehabilitation center, a police station, or such other place as the magistrate may order. This is because we have since passed the children's package, the children's court. This law does not contemplate with all of the amendments we made in relation to those laws that came after 2017, where the original draft of this bill came from. And therefore it would be unconstitutional to place a child in a prison. You have to have the constitutionality of the child going to a child rehabilitation center. In certain instances as well, you may wish to put somebody in St. Anne's or in a medical ward or in a hospital. So it would be unconstitutional to put that person in a prison or in a police station, in a lockup. So Clause 18 needs to have the return to the law as it's developed in relation to children and other places, child rehabilitation homes, etc. In the child rehabilitation rules that we passed, we allowed for alternative accommodation outside of children's prison, if I may call it that as well. So that's the rationale for going into a place that may be other than a prison or child rehabilitation center or a police station. Those are our submissions, Mr. Chairman.
Senator Honorable AJ, any comments? Right. Okay. The question is that Clause 18 be amended as circulated by Senator Dr. Marie. Those in favor say aye.
Aye.
Aye. Those against say no. No. I think the noes have it. The question is that Clause 18 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 18 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 18 now stands part of the bill. We have no amendments in 19 to 21. I'm taking all three clauses.
Clauses 19 to 21.
The question is that clauses 19 to 21 stand part of the bill. The question is that clauses 19 to 21 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 19 to 21 now stand part of the bill.
Clause 22.
The question is that clause 22 stand part of the bill. We have amendments from Dr. Murray, Senator De La Bastide, Senator Alwari, in that order. Senator Murray, the floor is yours.
Thank you, Mr. Chairman. Clause 22A refers to the wearing of body cameras as far as is possible having regard to available resources. So I think given the powers that the joint force will have, it should be mandatory that they wear their body cameras during the entire patrol from station and back to the station. So I think all resources should be provided for them to have the body cameras, and that's why I would like to delete as far as is possible having regard to available resources.
Thank you very much, Senator Michael De La Bastide.
Thank you, Chair. Chair, I had noticed Senator Murray's proposed amendment and Senator Alwari's at the time. I said to you I will be proceeding with my amendment to 22, but there's basically overlap there, so I'm just going to withdraw my proposed amendment.
Senator Alwari, the floor is yours.
Thank you, Mr. Chairman. Clause 22 is the clause that treats with the use of body cameras. The first thing that we wish to purge is the exception provided by the words that say, as far as is possible having regard to available resources. There are 2,000 body cameras in the possession of the TTPS, and we believe that any zone that has operations, there must be a mandatory use of police cameras. Similarly, in clause 22.2, by having the mandatory use, we think it necessary that the minister, again not the National Security Council, the minister, upon the advice of the NSC, after consultation with the Commissioner of Police and the Chief of Defence Staff, shall make standing orders for the mandatory use of body-worn cameras in zones, which shall be published in the Gazette twice in 2 daily newspapers in wide circulation and on the websites of the TTPS and the Ministry of National Security. We do that to make sure that there's certainty of the law, both for those who are actively using the body cameras and for those who wish to access it as persons who allege that they're victims of certain circumstances in zones. We also propose that we insert a new clause 22.3, that in addition to such other compliance required of police officers and members of Defence Force, that captures the language for police service regulations, police standing orders, that the Joint Command and every member of the Joint Force shall comply with the standing orders. And therefore, the tail end of that is to now say that notwithstanding that they may be charged with an offence under any other written law, that a person who commits a breach of subsection 1 commits a disciplinary offence. So we think it a must-have situation that for any zone of special operation, there must be a mandatory use of body cameras, and that there must be a mandatory code of conduct and standing orders, which is published, and that there be offences kept and preserved for breach of these laws, including disciplinary action. Those are our submissions on clause 22. Thank you, Mr. Chairman.
Attorney General.
Chair, there's already, as I understand it, a mandatory standing order on the use of body cameras. The difficulty is that I'm not as sanguine as my friend that there are 2,000 working body cameras, but I agree wholeheartedly and unreservedly that body cameras should be worn and that we should take steps to ensure that they are worn by persons within the group. So on this, I will wholeheartedly consider this matter.
Okay.
Mr. Chairman,
A question.
Before Dr. Murray.
Mr. Chairman, I listened closely to the Attorney General's response. Is the Attorney General willing to give an undertaking to this committee that he will delay implementation at least until such verification can be achieved that there are sufficient body cameras for all officers concerned?
I am loath to give an undertaking. I have stated my position. As you know, if I give an undertaking, that is that is something that brings certain consequences into play. I do not now know what is the state of the police service and their body cameras. I do know from where I sit that there was a dispute, contractual dispute, with respect to this issue. I'm not sure if this is a small country, and I'm sure that members on your side might know more about this than I do, but certainly body cameras should be worn by police officers. I cannot give an undertaking on it.
Mr. Chairman, I beg your indulgence. Sorry, I neglected to complete my amendments. There was also an amendment to Section 22(2)B and 22(2)D. In Section 22(2), it states that the Chief of Defense Staff and the Commissioner of Police shall establish the protocols and procedures for the use of body cameras. And 2B states that they can decide the categories of persons who may access the data collected and in what circumstances. So I'm proposing an amendment that these categories of persons must include the Police Complaints Authority, the Police Service Commission, branches within the Trinidad and Tobago Police Service that investigate police officers, such as the Police Complaints Division and the Professional Standards Bureau, and also restricted access to the Ombudsman and the Director of Public Prosecutions. So I just wanted those to be explicit in the law and not implied, so that these authorities could not be denied access to the data. As far as Section 22(2)D goes, I believe the Attorney General alluded to the fact that there are departmental orders already in place for the use of body cameras. So I just wanted 22(2)D to state that the body cameras must be used in accordance with those departmental orders. I think there's a Departmental Order 167 that refers to the use of body cameras. Thank you.
AJ? Would you like to comment?
There is no difficulty. They must wear there are standing orders. They've been enforced since, I'm told, August of 2017.
Yes, that's correct.
And with respect to the Director of Public Prosecutions and the Police Complaints Authority, I think that they would already have, certainly the police, the Professional Standards Bureau would have access to everything that the police has. And there would be procedures for the Police Complaints Authority to get a hold of it. I'm not sure that legislation is required for that, but again, we are ad idem on it. I don't think that you need to legislate for that.
So it's implied in the law that they will have access. So they cannot be denied access to the data, because it says here that the Chief of Defense Staff and Commissioner of Police shall establish the protocols and the procedures to provide for the categories of persons that may access. So as long as this does not prohibit access, then it's fine.
Well, yeah, I don't think that the protocols that may be established can override the existing law.
Okay, thank you.
The question is that clause 22 be amended as circulated by Dr. Marie. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 22 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 22 stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 22 now stands part of the bill.
Clause 23.
The question is that clause 23 stand part of the bill. Senator Alwari, SC.
Thank you, Mr. Chairman. Mr. Chairman, clause 23 is the requirement for ballistic signatures for ammunition by the TTPS and the Chief of Defense personnel, unless the Chief of Defense Staff or the Commissioner of Police determine otherwise.
Can I just say it's ballistic signature and ammunition?
Thank you. I accept the Honorable Attorney General's guidance. Forgive me, I'm focusing on the mischief in my mind, which is the ballistic signature. In looking at that, the caveat that applies to the requirement that the ballistic signature and ammunition assigned shall be registered with the Forensic Sciences Center prior to conduct is that the CDS or the COP may say no. We propose that that wording be deleted and that it is mandatory that ballistic signature and ammunition must be registered with the Forensic Center. We believe that that is to provide for the balance and concern as to tracing, particularly in killings that may be not accounted for, and we're quite aware that the population is concerned about these issues. So those are our submissions, Mr. Chairman.
No, I just said I'll consider that a useful point.
Okay, the question is that clause 23 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 23 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 23 now stands part of the bill. Okay, Honorable Senators, there's a procedural motion that we have to proceed with, and we shall now resume to accommodate that procedural motion. Common business.
Thank you, Mr. President. Mr. President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand.
Honorable Senators, the question is that the Senate continue to sit until the completion of the business at hand. Those in favor say aye. Those against say no. I think the ayes have it. The business of this Honorable Senate will continue until its completion at hand. The Senate will now resume in committee.
Clause 24.
The question is that clause 24 stand part of the bill. Senator Alwari, SC.
Thank you, Mr. Chairman. In keeping with our philosophy behind amendments that members of the joint force who exercise these powers ought to be members of the police force, we propose 3 amendments to clause 24 so that we're specifically ensuring that it is the police officer who is a member of the joint force who may do the respective things that are required. The rationale has been set out in the previous submissions that we've made, and we rely upon those. Thank you, Mr. Chairman.
Attorney General, you have any? Okay, I'll put a question at this time. The question is that clause 24 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 24 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 24 now stands part of the bill.
Clause 25.
The question is that clause 25 now stands part of the bill. Senator Alwari, SC.
Thank you, Mr. Chairman. Mr. Chairman, in seeking to provide constitutional support for this bill, we specifically looked at the Independent Commission of Investigations Act 2010, Act number 12 of 2010 of Jamaica, otherwise known as INDICOM. INDICOM is essentially the Jamaican equivalent of the Police Complaints Authority. It is, by its structure, a commission of parliament known as an independent commission, and it proposes that a commission is to be appointed by the Governor General in consultation with the Prime Minister, and after consultation with the Prime Minister and Leader of the Opposition, i.e. similar to our Section 80 of the Constitution, where the President, substituting General, the Governor General, can act in his or her own discretion. That's the first point. We propose that, as opposed to the bill's suggestion that the Prime Minister and Council appoint a committee called the Social Transformation Committee, that it should in fact be the President acting under Section 80 of our Constitution in his own discretion, in this case, her own discretion. The second aspect that we go to in borrowing from the INDICOM legislation in Jamaica is that the persons that populate this independent commission in Jamaica, as appointed by the Governor General in Jamaica, actually come from both sides of the House. In Jamaica, you will see that the leader of government business in the Senate, the leader of opposition business in the Senate, the leader of government business in the House, the leader of opposition business in the House, etc., are members of the committee who ultimately then choose who the independent commissioners are. We propose these amendments to provide the footing that the council that is to be prepared under Section 25 of this bill is not viewed to be merely an extension of the executive arm of the government. Instead, it provides the opportunity to have a degree of independence in the population of an independent committee. And it is for those reasons that we propose the amendments to Clause 25, borrowing from the precedents that I have referred you to Mr. Chairman. Thank you.
Attorney General.
Chairman, our constitutional structure, I mean, this is a question that we've been going around and around this evening. The powers of the President are set out in Section 80 of the Constitution, 81, 2, and 3 in particular. 81, that sets out the cases in which, under the Constitution, the President is required to act in his own discretion after consultation or in accordance with the advice. It is only in 83 that you get a delineation of 3 circumstances in which the President can act by himself. That is the power to appoint the Prime Minister, powers under Section 78, and an exercise of the power to appoint the leader of the opposition. Now, it is true that there are provision, there may be provision made in other law. We don't think that that is necessary here, and again, in other words, we don't agree.
The question, I'll now put a question. The question is that Clause 25 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 25 stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 25 now stands part of the bill.
Clause 26.
The question is that Clause 26 now stand part of the bill. We have Dr. Atz, Senator Dr. Atz, Dr. Murray, and those are the two in Clause 26. Dr. Atz?
Thank you, Chair. At this time, I wish to withdraw my proposed amendments to Clause 26.
Dr. Murray, the floor is yours.
Thank you, Mr. Chairman. My amendment is simply to propose a new sub-paragraph to 26.1, which outlines the functions of the committee, and that is to include that the committee should hold its first meeting within 1 month of being constituted, so that there's a timeline within which the committee must meet. Thank you.
Attorney General, do you have any intervention?
Within 1 month of being constituted, and they need to be constituted within 5 days of a zone being declared, yes.
Oh, that's an interesting point. I'll consider that as well, Chair.
Okay. All right. The question is that Clause 26 be amended as circulated by Senator Dr. Murray. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 26 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 26 now stands part of the bill.
Clause 27.
The question is that Clause 27 now stand part of the bill. No, let me just repeat that. The question is that Clause 27 stand part of the bill. Senator Alwari.
Mr. Chairman, my proposed amendment here was in keeping with the amendment that minister be defined, just to remove these words. We've already ruled on that, so the rationale is really so that we could tidy up the bill's language.
The question is that Clause 27 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 27 stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 27 now stands part of the bill.
Clause 28.
The question is that clause 28 stand part of the bill. Senator Vieira, SC.
Thank you, Chair.
Answer.
My amendments were looking at the question of parliamentary review. It seemed to me that the initial implementation phase carries the greatest risk of abuse, misunderstanding, or unintended consequences. I believe more frequent early reviews and quarterly reporting would allow rapid correction of unintended consequences. It will build public trust and confidence during the initial implementation, and transparency will protect both civilians and law enforcement officers. If these powers are truly necessary, Parliament should be willing to renew them, and if not, they should expire.
Senator Michael De La Bastide.
Chair, I withdraw my proposed amendment. Thank you.
Mr. Chairman, I was thinking pretty much along the same lines as Senator Vieira, but I had put it quite simply that we start reviewing the Act within 6 months, because by then we would have obviously realized that we're in conflict with the children's law package, we're in conflict with the AJIPA, we're in conflict with search warrants, a number of things. So the sooner we started tidying up the law, the better. So my proposal was for 6 months.
I would seriously consider Senator Vera's suggestions. I think that Senator Arawi is pretending not to know that AJIPA is dealing with administration of justice, and while the concepts in some regard are useful, that it really has very little to do with what is in fact a law enforcement and social transformation exercise.
Thank you, Mr. Chairman. Just to conclude my position. Thank you, Honourable Attorney General. Of course, I was speaking about the fact that you may be charged for an indictable offence, and therefore it is very relevant, just like the Summary Courts Act. So I thank you for the opportunity to clarify that.
All right, the question is that clause 28 be amended as circulated by Senator Anthony Vieira, SC. Those in favour say aye. Aye. Those against say no. I think the noes have it. The question is that clause 28 be amended as circulated by Senator Alwari, SC. Those in favour say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 28 stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 28 now stands part of the bill.
So we're going to start considering new clauses. The question now is questions of new clause by Senator Lowy will be read a second time. If it's not read.
It's called new clauses that have been proposed. The question is that new clause 4 be read a second time. Those in favor say aye. Aye. Those against say no. No. The noes have it. New clause 4 will not be read a second time. So we go to the next one. Next one. New clause 6A be read a second time. This is by Senator Dr. Marlene Nance. Those in favor say aye. Those against say no. I think the noes have it. New clause 6A will not be read a second time.
New clause 10A.
The question is that new clause 10A be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 10A will not be read a second time.
New clause 11A.
The question is that new clause 11A be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 11A will not be read a second time.
New clause 26A.
The question is that new clause 26A be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 26A will not be read a second time.
New clause 28A.
The question is that new clause 28A. Right. New clause 28A as circulated by Senator Anthony Vieira, SC. The question is that new clause 28A as circulated by Senator Vieira be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 28A as circulated by Senator Vieira will not be read a second time. The question is that new clause 28A as circulated by Senator Alwari be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 28A as circulated by Senator Alwari will not be read a second time.
New clause 28B.
The question is that new clause 28B be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 28B will not be read a second time.
New clause 29.
The question is that new clause 29 be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 29 will not be read a second time.
Now we move on to the schedule.
And the schedule starts after the bill, right?
Yeah, because the schedule stands part of the bill. Stand part of the bill.
Go ahead.
The schedule now stands part of the bill.
The question is that the schedule stand part of the bill.
And then we have senators.
Those.
We have Senator Dr. Hans, Senator Vieira, Senator Etienne, Senator Murray, and Senator Alwari.
I'm reminded we have amendments from the following senators: Dr. Marlene Atz, Senator Anthony Vieira, SC, Senator Etienne, and Senator Dr. Marie, along with Senator Alwari. In that order: Senator Anthony, Senator Dr. Marlene Atz.
Thank you, Chair. In looking at the schedule for the Social Transformation Committee, at item 1G, it was listed a representative of the ministry responsible for social security, and I wondered if that should be a representative of the Ministry of Social Development and Family Services. At 1H, it read a representative of the ministry responsible for national security, and I wish to suggest that that be replaced by a representative of the Ministry of Homeland Security. At 1J, on the schedule is presented a representative of the ministry responsible for economic growth, and I wish to suggest that that be replaced by a representative of the Ministry of Planning, Economic Affairs and Development. I wish to, with respect to 1R, which reads, a person who the minister is satisfied is a representative of a bona fide community group active in the zone. I wish to suggest that that be replaced by a representative of a bona fide community-based organization operating within the zone for a minimum of 3 years and who is nominated through a transparent and documented process and approved by the committee.
Senator Anthony Rivera, SC.
Thank you, Chair. My amendment was aimed towards amending the Social Transformation Committee to strengthen civilian oversight. And basically, I was piggybacking on the recommendation that had been made by the Law Association. While the committee includes community representation, it does not formally embed parliamentary oversight at the local level. So by making the constituency MP an ex officio member, you're strengthening civilian oversight, you're improving community trust, we are ensuring that Parliament will remain connected to lived impacts. It does not interfere with operations, and the perception of military or executive overreach would be mitigated. Thank you.
Etienne?
Referring to the persons that would be on the Transformation Committee, my opposed amendment was that it will be someone that the minister will choose that will have a disability. And in item X, from a bona fide NGO. Reason for this is because many times you have people that work alongside persons with disabilities, and they are qualified as well. However, they are not the person that living with the disability, and even though they may give recommendations, sometimes the recommendations would not be accurate. Also, people tend to choose someone without a disability that works alongside the person with the disability. So to strengthen it and to cover the persons with disabilities, my recommendation is that the minister will choose someone that has a disability from an NGO, a bona fide NGO. And the reason why I asked to expand it from National Center for Persons with Disabilities is because you may have 3 or 4 zones, and how could that one NGO cover persons that are qualified to be on the committee? So my opinion is that you expand it out to other capable and qualified NGOs so that they could also have someone that will be chosen from their organization to serve on the committee that has a disability.
Okay, thank you. I recognize Senator Desiree Murray.
Thank you, Mr. Chairman. My recommendation comes out of the recommendations following the review committee in Jamaica after the 3 years of the zones of special operations in that country. And they recommended that if a committee member was absent for 3 consecutive meetings, that they should be replaced by another person. We heard during the debate that many committees are constituted and persons don't attend regularly. So if the Social Transformation Committee is to be effective, then there should be regular attendance by the members constituting the committee, and I therefore recommend that if a member is absent for 3 consecutive meetings, that they be replaced. Thank you.
See.
Thank you so much, Mr. Chairman. Mr. Chairman, borrowing from the INDICOM structure, that is the Independent Commission of Investigations Act 2010 of Jamaica, I've proposed that in keeping with the amendments that I offered in respect of Clause 25, which we've dealt with already, for harmony, that it's the President, after consultation with the Prime Minister and Leader of the Opposition, may at his own discretion do these things. That is to take avail of the opportunity that the President has in Section 83 of our Constitution. I also proposed, similar to the Jamaican inclusion, that representatives of the Leader of the Opposition be included there. I note in some of the language of the bill, for instance, in 1R and S, that we refer to someone who, a person who the minister is satisfied is a representative, a person who the minister is satisfied lives. I don't know who that minister is, because the amendment that I propose that the minister be included in the definition section has been rejected. So you'd need some clarity as to who that minister is. So those are our submissions. It is to improve the constitutionality and balance of the legislation in keeping with precedent and the Constitution. And with respect to R&S, there certainly is need as to who this minister is, because there's no definition of minister.
Senator Avery Brown.
Thank you, Mr. Chairman. I don't know if the Attorney General is ready to proceed, but understood.
Right on, Senator Brown.
He's asked for a moment, Mr. Chairman. Ready? Chairman, thank you for the forbearance. This is not by way of scripted amendment, but requesting clarification from the Attorney General on the record with respect to Schedule 1B and C. 1B contemplates a zone that may straddle multiple constituencies and is scripted accordingly. 1C does not contemplate zones that straddle more than one regional corporation. Is this a matter that the government has considered? And if so, why have they not imported the language from the second portion of 1B into 1C? That is, if the zone is located in 2 or more regional corporations, the mayors or their nominees of the borough or chairman or their nominees will be included in the committee. So it's just for the clarification on the record. Is this something the government has contemplated?
Yes, AG, respond to those people, all those senators.
The points made by Senators Vera, Atz, and Etienne, those are matters that we would give serious consideration to. I'm not sure that I understood the acronym National Center for People with Disabilities and the distinction between the mischief there, why persons nominated by that entity could not represent persons with disabilities. But in principle, we would give serious consideration to that, subject to me having some sort of clarification on what exactly is meant by that. Senator Murray's point on the giving up of a seat, a place, if you miss, I mean, that is standard proper corporate governance now, that if you don't attend a certain number of meetings, you aren't interested, and that a replacement for you should be found. I don't see a problem with that, so that too I can agree with in principle. Senator Rawi's point on the President and the Prime Minister, I think we've spent a lot of time discussing that back and forth. So regrettably, again, I must disagree with you on that. There's one other. Oh, the names of the ministries. Those are things that change from time to time. So whereas I can see, and this is perhaps a good example of why we need to revisit, we will need to revisit this. Now, there is now no Ministry of National Security. There is a Ministry of Homeland Security. We do not know what the position will be in a year's time, in 6 months' time, and some of the other ministries that you referred to as well. I'm not sure about the Ministry of Social Security, if we've ever had a Ministry of Social Security. But if we can find, so I agree with the point in principle. If we can find a generic expression to cover.
Perhaps it is through the chairman, perhaps yes, a descriptor as opposed to a specific name.
Correct.
Because consistent with your point, Attorney General, at 1M does specify representative of the ministry, so perhaps a descriptor as opposed to specifying.
We run into problems as it is now with labels in different pieces of legislation. I have portfolio responsibility for something which is described to be the responsibility of the Ministry of National Security.
And what's the way the section is drafted?
Say again? I don't have sole responsibility for it, but I do have some responsibility for it. I'm sure you sleep comfortable at night knowing that. Exactly.
The way the section is drafted, wherever we say the minister, it has to be the Minister for National Security, because that's how it flows.
So, Chair?
Senator Brown asked a question.
Senator Brown's question, Senator Brown, I'm sorry, your question was lost.
Rationale for not contemplating in C that a zone can also cross multiple regional corporations. In B, the government has contemplated zones crossing multiple constituencies.
Well, I mean, in principle, I would think that a zone would be determined by prescriptive criteria. So if you have, to use the language of the Act, rampant criminality, gang-related criminality, then that would be whether it crosses a line or a street or something of the sort. So I'm not sure that I'm answering. I see you. Okay.
Not wishing to delay the Attorney General, Mr. Chairman, but if I could point you to 1B in the schedule, where the Member of Parliament of the constituency within which the zone is, or if the zone is located in 2 or more constituencies, plural, the Members of Parliament. And then I take you to C, the Mayor, so these are the members of the committee. The mayor or his nominee of the borough or chairman.
So I'll seriously, I see what you see. I'll take a look at it seriously.
Honorable Senators, I'll now have to put a question on each. The question is that the schedule be amended as circulated by Senator Dr. Marlene Atts. Those in favor say aye. Aye. Those against say no. No. The noes have it. The question is that the schedule be amended as circulated by Senator Anthony Vieira, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that the schedule be amended as circulated by Senator Etienne. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that the schedule be amended as circulated by Senator Dr. Desiree Marie. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that the schedule be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that the schedule now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. The schedule now stands part of the bill. All right.
The preamble.
The question is that the preamble to the bill be approved. Yes, Senator Alwari, you have an amendment, yes.
Mr. Chairman, for the record, I propose that the preamble be amended to include the fact that the bill, in our respectful view, requires a 2/3 majority and a 3/5 majority. The 3/5 majority is already included in the bill, so a collection of voices will require us today to go for 3/5 support. In our respectful view, Section 54 of the Constitution is, in fact, requiring a 2/3 majority, and we ought to be saying that this act shall be construed as altering the Constitution, which is the language one normally uses. The rationale for this is, specifically and succinctly, that this bill in Section 14, Clause 14, proposes to give police powers specifically to members of the Defence Force. The giving of police powers to members of the Defence Force means that the members of the Defence Force are going to be subject to the general and specific directions of the Minister and also the Defence Council, again chaired by the Minister. When we look to Section 54(4) of the Constitution, and we see that Section 54 calls for special majorities at 2/3 because of a number of circumstances, the language which I wish to put on the record at Section 54 is as follows. Section 54 of the Constitution, the marginal note is alteration of the Constitution. 54(6), says, in this section, references to the alteration of any of the provisions of the Constitution or the Trinidad and Tobago Independence Act 1962 includes references to repealing it, with or without reenactment thereof, or the making of different provisions in place thereof, or the making of provisions for any particular case or class of case inconsistent therewith, to modifying it and to suspending its operation for any period. The intrusion into the Constitution that I'm specifically referring to occurs under the rubric of the provisions of Chapter 9 of the Constitution, specifically the service commissions, and the fact that Police Service Commission in Section 122 of the Constitution is established and that the Police Service Commission in 123 deals with the powers that they have, in particular to discipline the police and the Commissioner of Police and the Deputy Commissioner of Police. And Section 123 of the Commission gives the Commissioner of Police power to manage police service. So the Commissioner of Police manages lower ranks, the Police Service Commission manages the Commissioner of Police and the Deputy Commissioner of Police. The Service Commission is an independent body which keeps the separation of powers position alive for us. Therefore, in seeking to have the Trinidad and Tobago Defence Force have, by express mention in Section 14 of this law, I don't know if Senator Swaratson has something to say. Oh, yeah. Go and take a break. You'll be all right. So, Mr. Chairman, in dealing with a serious issue of the Constitution, because we are not tired to deal with the constitutional rights of citizens, in seeking to have police powers expressly given to members of the Defence Force, it is for us clear that there is a modification of Section 9 of the Constitution and that a two-thirds majority is required by Section 54(6) of the Constitution, as I have read it out. Mr. Chairman, it is for this reason that the 2017 bill, which came under my tenure as the Attorney General, had Clause 4 of that bill saying that this act alters the Constitution. For the benefit of the record, I'm putting these positions on record in aid of the rule of pepper and heart for interpretation and for constitutional challenge. Perhaps Senator Swaratson will be satisfied to know that there's a reason that this is being put on the record. So, Mr. Chairman, these are the submissions as to why this bill requires not only a 3/5 majority, but a 2/3 majority, and why the law should state that in the preamble and in a new clause 4. For the last point now, the position in Jamaica, in their constitution in Section 13, both in the chapeau and in the choiseul of Section 13, there is a material difference in their constitutional arrangement. So the Jamaican laws never have the constitutional prescriptions that we do, because they have exceptions for public interest expressly stated in Section 13 of their constitution, which we do not have. Those are our submissions for the record, Mr. Chairman. I accept the Honourable Attorney General has already addressed that he does not agree with our submissions, but I've made them for the benefit of the record. Thank you.
No. General, you have any comments?
That's what other people should be saying, boy.
Chair, not only do I not agree, I think the Privy Council has ruled on this and definitively on it, and I disagree. The Privy Council disagrees as well.
All right. The question is that the preamble be amended as circulated by Senator Faris Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that the preamble to the bill be approved. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. The preamble to the bill is approved. The question is that the bill be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. The Honourable Attorney General.
Mr. President, I wish to report that the law reform Zones of Special Operations, Special Security, and Community Development Measures Bill 2026 was considered in Committee of the Whole and approved without amendment. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that this Senate agree with the committee's report on the law reform zone of special operations, special security, and community development measures bill 2026. Those in favor say aye. Those against say no. I think the ayes have it. The Honorable Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago, and for other related matters, be now read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety with certain geographically defined areas of Trinidad and Tobago, and for other related matters, be now read a third time and passed. Those in favor say aye. Aye. May I remind colleagues before we go to that part, this bill requires a 3/5 special majority vote, and the clerk will now conduct a division.
Mr. Alaha?
Yes.
Mr. Jeremy S.C.?
Yes.
Mr. Roberts?
Yes.
Dr. Swarat Singh?
Yes.
Mr. Maharaj?
Yes.
Mr. Batiste?
Yes.
Mr. Alexander?
Yes.
Mr. Ratiram?
Yes.
Professor Prasad?
Yes.
Dr. Chaitan Maharaj?
Yes.
Ms. Charles?
Yes.
Mr. Zakur?
Yes.
Mr. Smith?
Yes.
Mr. Naked?
Yes.
Mr. Rashid?
Yes.
Dr. Brown?
No.
Mr. Al-Rawi SC?
No.
Mrs. Roberts Rajman?
No.
Mr. Cummings?
No.
Mrs. John Bates?
No.
Mr. Boodoo?
No.
Mr. Vieira SC?
No.
Ms. Choate SC?
No.
Dr. Axe?
No.
Mr. De La Bastide SC?
No.
Ms. Joan Simmons?
No.
Mr. Lewis?
No.
Dr. Murray?
No.
Mrs. Lalit Etienne?
No.
Mr. McNish?
Abstain.
Mr. President, the results of the division are as follows. 15 senators voted for the bill, 14 senators voted against the bill, and there was one
Honorable Senators, as a result of the division, 15 members voted for the bill, 14 members voted against the bill, and there was one abstention. The bill has not been approved. The Honorable Leader of the House.
Mr. President, I beg to move that the Senate do now adjourn to a date to be fixed.
Honorable Senators, the question is that the Senate do now adjourn to a date to be fixed. Those in favor say aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to a date to be fixed.